Thank you for joining us today. I'd like to welcome everyone to today's webinar, Cybersecurity Requirements for Financial Services Companies, specifically the 23 NYCRR Part 500. In today's webinar, our guest panel will speak about the key points on the legislation and strategies to help you comply. Let's go ahead and get started. At this time, I'd like to introduce our presenters. So joining us today is John Ford. John Ford is the founder and CEO of Sienna Group, a leading provider of data-centric security solutions to help organizations protect their most sensitive information. John has over 20 years of compliance and information security, including C-level information security and compliance roles with several Fortune 500 companies. Welcome, John.
Thank you.
And I'd also like to introduce Scott Giordano, a highly regarded data privacy attorney with over 20 years of experience and currently Vice President of Data Protection at Spirin. Welcome, Scott.
Thanks for having me on board.
So at this point, I'd like to hand the presentation over to Scott to get us kicked off.
Thank you, Doug. On our presentation today, we're going to talk about some of the finer points of Section 500. And with respect to that, I'm going to kick things off with talking about how the data protection landscape has changed since this regulation was put in place. We'll go over some key provisions and the specifics of 500.13, some strategies to comply, including a display of a sample data classification schema, and then we'll offer some recommendations for best practices for compliance before the upcoming deadline. So with that, Doug, why don't we talk about some of the latest unofficial news? And again, this is all unofficial, folks. I was at the IAPP event in Austin recently and talked to some of the folks who were involved in the NAIC version of the Part 500, which if you're been involved in this from the get-go, then you're probably well-versed with that version as well. So what they told me, and again, this is unofficial, but I want to share it with you because I think it's very important to our efforts here in getting compliance complete by the deadline. And one is that as expected, Rhode Island is likely the next state to adopt the NAIC version of the Part 500, which is great news. South Carolina became the first this year, and so Rhode Island is likely the next. That's per some of the experts with the NAIC version. Also, they believe that about 20 state legislatures are going to take up the NAIC version of Part 500 in the next legislative session, which begins typically in January. So we can look to see other versions or other instances of the NAIC version popping up in the next 12 months or so. Also, they told me that the U.S. Department of the Treasury is very positive with respect to these requirements. And so I think the net of it is that you're going to see that Part 500 is going to be one of these unofficial national standards in the sense that other organizations are going to be subject to it. It won't be just those that have licensure in New York. So I think it's good news if you enjoy consistency among all of the different places in which you operate, then I think this is good news on the horizon. All right, Doug, if we go to the next slide, I want to also give some updates just on data protection in general. What's interesting is in the past 12 or so months, we've seen several new data protection requirements come into law. And I know that probably everyone on this call, if you spend any time at all in data protection, you're already well versed with the California Consumer Privacy Act, which was brought into force this year, very hastily, I might add. Also, though, California also brought into force the first, I guess we would call it internet-connected device legislation specifically on default password and addressing how they no longer can ship with default passwords and other aspects of IoT security. So that was very interesting. We're having other ones like Colorado and Virginia and Vermont and Alabama, just a variety of different data protection regulations that have come into force in the last 12 months. And this is not an accident. In fact, what it really does, it represents a sea change in how we're going to address data protection here in the U.S. I believe, and again, this is just my professional opinion, but I think it's the correct one, is that this is going to be a completely state-led effort. So you're going to see all these different state-level requirements, statutes, regulations, however it's embodied, they're going to be what's going to lead data protection in the U.S. So if you're someone who functions in all 50 states, it's going to be a much larger burden, I think, than it would have otherwise with a single national standard like GDPR is for companies that process personal data of EU data subjects. But the net of it is this is where we are right now with respect to data protection in the US. And so you're going to see changes in the nature of data breach. You're going to see changes in the nature of how data brokers are regulated. You're going to see banking regulations like and the NAIC version that was passed in South Carolina. All of this is going to be what I think is the wave of the future. I do not see any data protection regulations at a national level on the horizon. I know that some folks in the privacy and security industry have said, oh yeah, we'll get a national data protection regulation. Here's the problem with that, is that there's a big fight over what's called preemption. And you may have heard a little bit about this when we discussed in the past the FTC net neutrality rules and how they work vis-a-vis states. The idea of preemption is that in many cases, a federal law will simply preempt any state laws that conflict with it. And so it sets a bar and says, this is how we're going to do things nationally. There's no variation. So the canned spam law, for example, that came about many years ago, that's something that used federal preemption. So only the federal government can effectively address that. Whereas other regulations like healthcare or pollution regulations will set a floor, but not a ceiling, and states can create a ceiling if they want. So they avoid preemption. So this is the fight that we're having right now over federal data protection. I don't see the federal government being able to win the preemption fight, which means that even if we do have a national privacy or statute, I think you're going to find that the states are still going to have their own versions of it that we'll be able to layer on top of that. That's what I suspect is going to happen. There's been some disagreement about that, but I suspect that's where we are. This regulation, I'm not going to dig too deeply into it because if you've been involved in this last 2 years or so, then you're already well versed with it. So let me just share with you the big picture. One of which is that this applies to all financial institutions that operate under licensure under NYDFS. Also applies to their third-party service providers. So in the same way that GDPR requires data controllers and data processors to be held to essentially the same standard, this is true as well for NYDFS. Also, what I thought was fascinating was that on June 25th of this year, credit reporting agencies, CRAs, are now added to the list of covered entities. I think that that was largely a result of the Equifax breach, and so it just adds another set of institutions that are now subject to this. So it's an interesting turn. In terms of the what, all of you on this call probably are far along in your compliance regime, so you're well versed with the what. Essentially, this was done over a 2-year period, with the upcoming period in March being the final one. And during that course of that, there were certain deadlines for certifications to be done, etc. And so we started off with cybersecurity policy, then went to reporting procedures, a program in and of itself, and now upcoming is securing third parties. Why is this in place? I mean, I think it may be obvious that, well, why? It's because we want to make sure the institutions are secure. I think that's pretty obvious, but from a larger perspective, there haven't been a lot of massive breaches in the financial services industry over the past 3 years vis-a-vis other ones. I mean, we're all familiar with the ones that happened at Office of Personnel Management, for example, but there really haven't been those kind of signature attacks that have been making the kind of news that other attacks have. But really, this has been a function of a 3-year effort to review the state of security for financial institutions. As a consequence, these regulations were promulgated almost 2 years ago. So the upcoming deadline, March 1st, is going to be really with respect to third-party vendors. There's been other certifications as well. Doug, I'm going to do a full stop there before I hand over to John and talk about some of the key provisions.
Thanks, Scott. Welcome, everybody, and thanks for taking the time to join us today. So as Scott mentioned, he outlined, essentially, what the New York State DFS is. Some of the key provisions here, as most of the folks on the call, I'm sure you've been following this, along for the past couple of years. They're not lost on you, but, encryption, appointment of a CISO, establishing a program, a security program, and then, Scott just mentioned components regarding third parties. I think what we want to take a particular focus on today, though, is the limitations of data retention, which really becomes the focus of this webinar today. So Doug, if you wouldn't mind. All right, so this section 500.13, the way it's read, limitations on data retention, is pretty straightforward, and it defines basically what MPI is. Obviously, the personally identifiable financial information that institutions collect in offering products and services to citizens. This also really assumes that to retain data, we have to know that we have data, and we have to know where it is, and we have to be able to identify it, right? So, there's a lot of components that go into this as we work through with our customers, and in my experience in the past of being a CISO in organizations, it seems like this piece, 500.13, assumes an awful lot that some companies would have in order. So I'll talk about these pieces, kind of a strategy to comply, but essentially, in order for you to retain and delete information that would be part of New York State DFS, you have to know how to discover it, and you have to know how it flows through your organization. You have to know where it resides. And I'm not just talking about file shares or laptops or desktops. We're talking about both structured and unstructured data repositories. And this is where it gets a little bit difficult, because in a lot of cases, if you think about your relationship, your infrastructure that you have, maybe you have some on-prem, maybe you have a lot of cloud infrastructure, your business partner relationships, your client relationships, there's data being proliferated everywhere, as I'm sure everybody on the call knows. And when, in order to be able to set a retention schedule, you absolutely have to know where this data is at all times. So, our partnership with Spirion, we do a lot of work with not only discovery of data and then identification, but classification of data. And I'll get into this a little bit downstream, but this doesn't just go for New York State DFS. This is valuable to you and all of your regulatory needs, as well as sensitive data to your company, be they trade secrets or other IP. But the goal obviously would be to identify, classify data appropriately, being able to set protection profiles to that data, and then leverage that classification schema so that we can properly delete data on a normal scheduled basis. Scott's going to have a couple of slides on the schema coming up. I think importantly too, what we see with our clients today is the ability to visualize and monitor the data. It's one thing to have a data classification program in place, but we oftentimes say, well, how do you know that's working? If you can't see how that data is being visualized through your organization, you might be classifying information, but maybe you're not doing it properly. Or you might be classifying information, but providing access of that information to the wrong people in your organizations. Or, you might be classifying information, but you're not taking advantage of other components of your infrastructure that could help protect that information. So one of the key components here, of this section, not only, for deletion purposes, is that you have the ability to visualize and monitor the data as it's, at data at rest, in motion, and in use.
Before I do, there's a couple of questions. So one regarding data retention. How can we prove that data is only retained for a certain time frame? Do policies suffice, or do we need data destruction proof?
Well, from my seat to stands, my opinion is you need both, right? So you can have a policy, but if you can't demonstrate a process and show that data, in fact, has been deleted, then I do not believe that you're compliant to the limitations of data retention component. Scott, do you have, from more of the legal side, do you have an opinion on that?
I agree. You're going to have to provide some kind of objective evidence as to how the deletion took place. You may even be required to certify that it was destroyed. And I'll give you an example, not of NYC, but just of e-discovery projects that I've worked on, where after the litigation was over, then the parties that were holding the data that was involved in the litigation had to certify that they had destroyed it. And they had to attest to that so that if something went wrong down the road and that data reappeared somewhere, then they would be essentially holding the bag. So the same is true here. There's going to have to be some kind of attestation, almost certainly, if not just a regular report delineating exactly what was deleted, when it was deleted, and who was in charge.
Great, thanks. There was another question regarding third parties. So regarding third parties, do we have to review all third parties, or is a risk-based approach sufficient?
Not sure I understand in the context. When we say review, all third parties. If we're talking about extending the requirements of 500.13 down to third parties, I would say yes. However, not all third parties are created the same. Some of them might be doing some obvious business for you with respect to anything that would adhere to New York State DFS, but you might have other third parties that are not handling that information, and a risk-based approach should be fine. But I would say, and Scott, I'll defer to you, but I would say if they are acting on your behalf in any way in the performance of providing financial products and services within the scope of New York State DFS, and they in fact would have to adhere to the same restrictions.
Yeah, I agree. All third parties do have to adhere to the same set of rules. I think in terms of a risk-based approach, you would use that to determine who gets the most scrutiny. So the higher the risk to personal data or to sensitive information, the more scrutiny that third party is going to get. And this really, where this comes up is an audit. And I've had this discussion so many times about what can be audited, who can do the auditing, is just showing a SOC 2 enough, et cetera. So that's something that the higher the risk, the more terms that your counsel is going to put into their agreement. And then the question is, how do you enforce that? So all of that is a function of a risk-based approach. And the higher the risk, the more scrutiny and the more intensity of action you're going to have with that third party.
I'm going to turn this over to Scott, but Scott was able to provide a wonderful example of a data classification schema. And Scott, why don't you walk the audience through what you have here?
Sure, and this is based on a true schema I developed. It's the original schema of which this is a subset was much larger. I think we had 7 different classifications, and it went, I think, to about 17 or 18 pages, and this was just the schema. Boiling this down to a sample like this, it's still very instructive. The idea behind it is that the first thing you'll do is create very rough buckets of where you think sensitive data should be. So, for example, if it's class 3, proprietary and sensitive, so it's personal data or PII, including HIPAA control data, attorney-client privilege materials, it's a rough bucket of you're saying, okay, proprietary and sensitive, we think that's on a scale of 1 to 4, that's number 3. Whereas things that are especially sensitive, special categories of non-U.S. data like religious affiliation or political activities, etc., that's got the most, or perhaps things that are trade secrets. So you have to create very big buckets of these, and then you ask yourself, okay, great. As a consequence, what happens if those things are mishandled? What happens if you lose attorney-client privilege materials? Well, you lose the privilege. It's been exposed to the public, for example, or a trade secret. It's been exposed to the public. Well, how much damage is that going to create? Likely substantial or significant. So as a consequence, you're going to say that's class 3 or that's class 4. And so you'll continue to refine those big buckets until they're much more sharply delineated. And then you'll ask yourself, what kind of controls are you willing to tolerate? And here's a great example. Is originally when I developed the first schema I'd worked on, I had attorney-client privilege materials in the red zone, meaning that you could not fax them. Now, the problem is a lot of attorneys still like using faxes. And so essentially they weren't going to cooperate with that. So I had to push attorney-client privilege materials back down a level to yellow level, because at least we could put controls there that people would adhere to. If you're going to have a control that no one's going to adhere to, there's no control at all, and you might as well not even put it there in the first place. So as a consequence, you always want to think about the reality of the controls you're putting in place. Are you fine-tuning your identity access management? Are you encrypting things? There's all kinds of controls that are appropriate for a specific scenario. And if you go to the next slide, Doug, I created several different media that we can talk about. Again, this was much larger in the original. So email that's within, between offices or within a group, work group, versus email sent to a third party, or versus electronic file mechanisms, or web portals, or the public internet versus a private intranet, etc. So there's going to be different standards that you're going to have to apply, and it forces you to think through a lot of scenarios that you would not have thought through before. And then as a consequence, once you have these scenarios and everyone's willing to adhere to them, then the data classification goes into place. And information files, documents, etc., when they're labeled with yellow or with R or P3 or whatever whatever mechanism that you want. Now that attaches persistently to that document or that file, and it flows through your information ecosystem. And so now everything can see that. I believe I tailed this off with a couple more. Audio, web, and internet connections, removable media as well, hard drives, et cetera, et cetera. So different standards. So again, this is a real schema. It's been simplified just for purposes of discussion, but this is what a real schema looks like. And in terms of what the documents or the files look like when they're labeled thusly, if you go to the next slide, on the upper left, we can see that all the different things, for example, company profile, that's green, that's level 1 versus correspondence with internal, level 2, etc. So you can see that these files are labeled so that there's a visual representation. So you can instantly look at something and go, aha, this is class 4 or this is restricted or whatever nomenclature you're using. If you want to see a concise picture of the state of all of those, well, then before you is the single pane of glass that we have, where we show all the different classifications, what degree of information is protected versus not protected over time, et cetera, et cetera. So essentially, you're getting a dashboard for everything that gives you the ability to provide command and control for your entire program. And this doesn't have to be limited to NYCRR. This could be anything. And in fact, if you're a multinational, you'll probably have several different regimes that you're required to adhere to. It's going to be GDPR, NYCDFS, and your state and local requirements, and any industry requirements like PCI DSS, and so forth. So the net of is seeing that all as one single sheet of glass, if you will, being able to get the state of your program at any given time. That's what this screen represents, and this is the capability that we have. John, let me transfer back to you because I really want to talk about the parallels between NYCDFS and other things as well.
And by the way, that's a great dashboard. It goes back to the concept I was referring to earlier about visualizing your data. So thank you for that, Scott. We talked earlier on about, states having regulations. We know New York State does NAIC, model regulations, the California Consumer Privacy Act, the GDPR. All of these requirements and regulations have some common themes, though. So it's, when you look at it from a program perspective, and I'm sure for the people on the call, this is, really a no-brainer, but you're going to build your data protection program not so much around one specific thing like GDPR, New York State DFS. You're going to build it around what are the components in play that I have for the regulations that I'm facing, right? And so, all of them generally have some sort of reference to the protection of personal information, that you have a formal and defined program in place, some governance structure where you can report out on, accountability, obviously incident response and breach notification, and that you have a handle on your third-party vendor management. So when you're looking at building out your capabilities, it's rare to me anyway at Sienna Group that we come across a customer that has a single focus on, say, GDPR without having to focus on something else. And so, we use the term 2 birds with 1 stone, and to choose your investment wisely when building out your programs to ensure that from a data perspective that you can basically discover and identify and classify all of your data and leverage that across all of these regulatory requirements, right? Again, I touched on it. I know Scott referenced it as well. This is insanely valuable for items like trade secrets. We do a fair amount of work at Sienna with helping people protect trade secrets. It's the same process that we would go about for protecting GDPR as far as identification, classification, and protection. So, essentially you get, more bang for the buck. The reality is, you should be taking a holistic approach and making sure that your program maps across these different vehicles as opposed to, trying to solve a point solution thing for, one particular requirement. I do know, having been in this business a while, some of them do have one-off requirements. There might be a PCI requirement that's different than you might see. And of course, you'd have to cover off on that. But in general, from a programmatic approach and a discovery, classification, and protection approach, this is much more of a programmatic scenario as opposed to treating it like a project, right? Projects have defined end dates, at least most of them do, but a program is really something that needs to be funded and managed in your environment as a function of you doing business.
There's a couple questions. So
Okay.
how would you tackle PII, NPI data flowing through corporate emails?
How would we tackle it? Well, we have the ability to classify, just identify and classify PII today. So we can do that with Spirion today. That's not a problem at all for email.
Great, thanks. The second question, I'll just read it as is. GDPR allows an approach to compliance being a work in progress. Does the same go for NYDFS?
Well, I'll lead this off and then I'll turn it over to Scott. I think there's a significant difference between the two in that regard, and the fact that, New York State DFS has given us controlled dates where items have to be attested to. And GDPR is much more of a function of a work in progress. And while there are dates for be compliant with all of GDPR, to me, they're structurally different in both their intent and how they would approach, your program's maturity. Scott, do you want to add to that?
Well, I agree with you that they are very different in that respect, especially since there's, at the moment, no certification required for GDPR. Now, that being said, here's the problem. Even though you may not be certifying to a data protection authority or a supervisory authority, as they're called now, the problem is that you're going to be certifying or attesting in a contract that you're able to meet those terms. So that may well be a distinction without a difference. Typically, and these are all the agreements that I've worked on before I actually joined Spirion. I worked on a lot of these data protection agreements where you're essentially certifying to a certain standard, and it could be something that was promulgated by NIST or was promulgated by ISO of some type, or it was anything else. So the net of it is once you've certified to that, you're essentially in the same boat, whether it's to a third party or to a customer or to an agency. Once you're certified, you're certified. So there's no layered means of rolling in a GDPR deadline like there is now for NYDFS. You just had to be quote unquote compliant by last May 25th. The question is, what does compliance mean? We don't know yet because there's no audit standard. So it's going to be a best guess, but it's going to have to be a very good guess because of just the magnitude of the threats that we face.
Excellent.
Thank you. And I think on this, we put down some recommendations here. Obviously, gap analysis, performance. I'm sure most of the folks on the call is a very common practice. I'm sure that if you have not done it, you're probably in the process of doing so. Another item that that I come across both when I was in the enterprise as a CISO, but also in our work with our customers is I strongly recommend in your quest to identify and classify data that you stay in concert with your legal team for their interpretation of New York State DFS, as well as terminologies that they may have used contractually that you need to be aware of and monitor for. So it's very important that in a sense, I've seen it where companies have actually put themselves at additional risk because of the terminology that they've used just because they wanted to go out and classify information and they did not consult properly with their legal team. And then before I turn it over to Scott, another thing that we see a lot at Sienna is we can do a lot with technology, but once we classify information and we have metadata on email and documents, we can do a lot with a lot of the existing infrastructure to enable the protection of that information, enable the visualization. We strongly encourage that you lead with process as a component of really, it's the process that's really going to lead you to a defensible position with respect to items like New York State DFS or GDPR. Well, Scott, do you have any other additional items you want to add there as far as recommendations?
Yeah, I really want to, and forgive me to the audience if you've heard this before, because I tend to make the same point repeatedly because it bears repeating. You have to have a solid data inventory, otherwise nothing else is going to work. You have to go through all the systems that likely process this kind of data. Because remember, it's not just quote-unquote personal data that's identified, it's sensitive data as well. So think about trade secrets that you might have, or even just information that third parties don't want you to release or that you shouldn't be releasing for some other reason. So you really have to go through that process and ask yourself, what applications are processing this and with what applications are they sharing it? It's very easy to say, okay, we're going to lock down System S and we're going to make sure that we've got everything labeled and classified and all that, but you have to ask, what is that feeding into? And look at that thing and say, what is that feeding into? What was infamous for this when I was working on GDPR projects was HR systems, where they would share with one thing and that thing would share with another thing and then another thing. And before you know it, you have all the sharing and none of those other systems downstream have been controlled. They're not aware of data classification labels. They're not working as a team. And so it always goes back to looking at your data inventory and making sure that you've checked and everything is where you think it is. Because I can tell you the bad guys are very good at finding personal data. And as a consequence, we have to be at least as good as they are.
So, question from the audience, are there any best practices, recommendations regarding establishing processes?
So let me take a stab at that, Scott, and then I'll turn it over to you. What I found in doing this as a CISO for a couple of companies is that it's very company specific. What I also find at Sienna with our customers is that it is also customers, a business specific. But there are best practices. I mean, first and foremost, again, I mentioned being in coordination with legal department, but obviously you need to have, as far as best practices, the semblance of a data protection program, an understanding even, prior to you discovering and identifying the data that exists on structured and unstructured repositories, the business use of the data that your company has and what the anticipated data flows are, making sure that employees are well trained on items like data handling guidelines. Those to me are critical. Again, I reference leading with process and enable with technology. You have to have those in play in order to have a successful data protection program. And it has to be well communicated to your employees, right? As well as your third-party business relationships, obviously to your leadership, right? Beyond that, though, when it comes down to the actual implementation of technology and how the technology interacts with other technologies, we have some, I'll call them like 75% of company A looks like company B. In a large perspective, there's no cookie cutter process there. It's really sitting down and really understanding, the architecture and implementation and outcomes. Scott, you have any thoughts there?
Yeah, I have two thoughts. One, and I'm going to pick up on this training idea you brought up earlier. The best data protection control ever invented is an alert employee. I can tell you that in my own experience managing data protection programs that I had employees come up to me and say, hey, did you know we were doing this with this data? And I would say, no, I had no idea. And it's those kind of things that are so important to the integrity of your program. Make sure that your employees, your team members are all adequately trained on both privacy and security. So privacy in the sense of, well, what qualifies as personal data? What qualifies as confidential data? How many times have we all seen in the past personal or confidential information that's left on a copy machine or coming out of a fax machine? It's one of the reasons that I have such hostility towards fax machines, because I've seen all kinds of things that should have never been faxed. So it really goes back to an alert employee. And then secondly, making sure that you can prove everything that you're doing. I've seen companies that do a wonderful job of protecting data, but can't show it. They can only talk about it. And if a third party wants to see your proof, you don't have it. Or if a regulatory authority wants to see your proof, you don't have it, and so you're not getting credit for what you're doing. So that goes back to reporting. It goes back to being able to attest to things or to certify things. And legal should be there with you every step of the way. And I apologize to any legal team members that I've just made a lot of work for, but this is part and parcel now of data protection. Legal is essential, and they have to be there to go over, especially contracts and agreements, and make sure that you're not agreeing to something that you can't ultimately do, because believe me, down the road, someone's going to point to that clause and say, hey, you said you would do this, and now you're not.
Great, thanks. Another question from participants. How far do we have to go with technology in securing our data? Do we have to monitor data in motion down to the packet level to feel confident?
We're at a point in time, not just with regulation, but I think when you just look at the available technology today that you have, I wish when I was a CISO that we had the technology that's available today, because trust me, I would have deployed it. I think you have to be comprehensive in your approach to protect data at rest, in motion, and in use. And when we talk about packet level, that indicates to me a network packet, which is slightly different than I think the concepts what we're introducing here about adding metadata to documents and emails so that we can track the data, right? I'm not saying that we forego network security, not by any stretch, but I think, you have to have a comprehensive at rest, in motion, in use, as well as solid grasp on what you're encrypting and what you're not. Scott, I don't know if you have anything to add on that.
Well, you think about controls in general, and when you look at a control set, and we'll say it's ISO 2700 series, or it's NIST 171, or what have you, controls always represent a consensus of all of the practitioners in that relevant community. So I would go back to the audience and say, what are your peers doing in the industry? What are recommendations from industry bodies? I don't know if it's FFIEC or that you would go to, or OCC, or whoever is giving these recommendations. What are they doing? Or what are they recommending? Or what are your peers recommending when you're going to conferences? Because if something bad does happen and you have to go to court, what's the question they're going to ask? Well, what is the standard? Standard really is just a generally accepted set of controls in a relevant scientific or technical community. And so if everyone in your organization, in your industry is doing a deep packet inspection, then yeah, you better be doing deep packet inspection, unless you can show why your scenario is different and why a compensating control is going to be just as good or even better.
Just to add to that, I would just say, if it is that you're doing data at rest, but you're not doing data in use or in motion, on the other side of a bad event, regardless of what your community is doing, you're going to have to address that. So I think a holistic program really tackles all three. And I think that we have the capability today where we didn't have it in years past to actually do all three. We're at the summary and conclusion slide. Again, there's a lot of information. I want to thank Scott. He added a ton of relevant information on the regulation, but brings it from that legal perspective. And we talked about there's many moving parts to this as far as integrated compliance deadlines, the fact that we need attestations. We also talked about upfront effort is transferable and, leading with process, enabling with technology. This is a journey, folks. This isn't it's not a project, and, don't treat it as a project. Treat it as a process that's a part of you doing business moving forward today, and I think you'll be fine. Scott?
Yeah, I would definitely take an approach of looking at all of the data protection requirements that you either have now or are going to have. And again, California Consumer Privacy Act being a case in point, and rationalizing those, saying, okay, what are all the controls that I'm going to need in place, and what one control can address many categories. And this is nothing unusual. I'm sure the audience members are all well versed with all the crosswalks that are out there from one regulation to another, but layer into that the idea of data privacy as well. And that you may be very good with the security piece and putting in controls in place per the laws and the regulations. But then the question is, great, when you're sharing that data or you're processing it, you're on the other end and you're processing it on behalf of someone else. Well, what are the rules there and what controls are in place there? I find that the biggest challenge of data protection today is not whether you have a particular control in place, but whether you know with whom you're sharing the data and what they're up to. Because you can do a lot with even very narrow categories of data. I spoke a couple weeks ago about what happens when you have just, say, GPS data. What can you do with it? And if you have enough of it, you can do a surprising amount. So I think that's something that everyone in the audience really wants to take a hard look at and say, look, we know that CCPA is coming up. We know these state breach level requirements are changing over time. The deadlines are shortening, and certainly the deadline for breach notification under NYC is 72 hours. So that's pretty difficult. That's GDPR, that's Department of Defense standards. So from that perspective, taking this bigger picture and saying, what are all the things we're going to have to do, and building that into your program. And it's going to be a lengthy process, but it's better to start doing that now to be able to incorporate that. And in fact, in a couple of weeks, I'll be doing a webinar just on CCPA versus GDPR and what you can learn from complying with one and applying that to the others. So be on the lookout for that. That will be coming up shortly.
All right, great. We'd like to open this webinar up for Q&A now. So I do have a number of questions. The first is in regards to audit trail requirements. How far do your clients go typically? For example, app logs, platform logs, firewall logs, et cetera?
It's a very interesting question. Typically what I see in the industry today is about 90 days. And I think, there's a lot that goes into that question. One, for sure, whatever you However long you're retaining logs, they have to be one in concert with any requirement you have. So for instance, DFARS requirements might have a particular requirement that you hold those logs for longer than 90 days. However, I would say if you just look at, what I see commonly out there is 90 days of logs. And so it seems reasonable to me, other than things that are required differently, whether that be a particular requirement that you have coming down from, either whether it be a customer or other relationship contractual environment.
Excellent, thanks. A couple of other questions. We have a lot of compliance requirements and we do not seem to have a good hold on all that we're accountable for. Can you give me your thoughts on what best to focus on?
Yeah, so let me jump on this one, and Scott, I'll turn it over to you. But I think this is very similar to the slide that we discussed earlier with two birds and one stone. There's a significant overlap. There's a lot of mapping between these requirements when you look at them from a control perspective. But they all do center around some key items of ownership, governance, data identification, protection, monitoring, and response. So when you're building out if you have an existing data protection program, or if you're just building one out, realistically, one, you can get a really good sense on what to do by looking at the mapping of controls that are out there across various items, whether that be NIST, ISO, FFIEC, however, right? And then looking at the common themes, right? So, that we address in the slide. Scott, you want to add to that?
Well, and forgive me if I'm pulling legal back into this, but in terms of things that trying to be able to prioritize, I would ask them what kind of certifications they've done or any kind of promises they've made in signing some kind of a data transfer agreement. And I reviewed many of them. And if legal is the only one who's looking at this and they haven't brought IT or InfoSec into the mix to make sure that there's a common understanding of what needs to be done, then I would put that as a priority list. To the degree that you can get your legal folks involved and say, well, what do you think is important for you from your perspective, then that's going to be something you want to add to the list.
Great, thank you. It looks like there's another question. How do we get a handle on the data side of this issue? We have tons of data, and I'm not sure anyone knows at any given moment where it is nor how it's being used.
All right, so this is a question that's near and dear to my heart because I had the unfortunate opportunity to sit in front of a board of directors and have them ask me, John, how much EPHI do we have in this company? And giving them a blank stare and saying, I have no idea. So this is one of the benefits of what we have today by being able to discover and classify data, right? You simply just have to get a handle on identifying this data, and the technologies are out there. Experion, being one, right, where we can identify and classify data. When you start doing that, and you can do that in an automated fashion, you'll not only get to see an inventory of the data as you're classifying it, right, whether that's at rest, emotion, and use, but then you'll also get the benefit of seeing how that data behaves in your organization and how well you're protecting that, say with respect to your data handling guidelines, right? So in this model, that's where we could take advantage of looking at the rest of the IT infrastructure and saying, hey, how can I leverage, maybe some of these other components I've already purchased that might also be able to look at this data and, take action, whether that be a DLP or next generation firewall, what have you, right? The days are gone where we do everything around data, but we don't touch the data. We need to classify data, discover it and classify it in order to get to a point where you can talk intelligently about how much you have and how it's being used. A long-winded answer, but I hope that helps. Scott, any thoughts there?
Sure. I would start with a small project of some application. It doesn't have to be necessarily anything that's even on point for Part 500 at the moment. What I would do is interview the business or the technical owner, get his or her view on what qualifies as personal data or sensitive or confidential information, and build out that data inventory, if you will, that sample inventory, and then test it out using a system to be able to do data discovery and find out if what you thought is there actually is there. And do that iteration, then go back to the owner. It could be a business owner or a technical owner, and say, hey, I found this here. Is this qualify as personal data? And you're going to find that in many cases, there's going to be things that are there you didn't realize were there, or things were being collected. For example, I had one client that was collecting MAC addresses because this was something that had been done for such a long time and didn't even realize it. And so they said, we don't need these anymore. And they just started not collecting them. It goes back to the question, do you know where the data is? Talk to the business or technical owner of a system, and then get an idea of where it really is after you've talked to them, because over time, you're going to find that these orphaned file servers or shares or what have you have personal data that you didn't know was there. So do data discovery afterwards, make sure that you're validating, then come back to the owner and say, hey, let's do another round of this, and keep doing that until you run it to ground. Once you get that down to a science, then start tackling the bigger systems, whether it's an Oracle system or whatever you have. And then also make sure that if you have an app that's attached to the services you provide, say that you're a B2C, not just B2B, and you have an app that you publish to communicate with your clients, make sure that you've tested that as well, because apps are notorious for sharing data and they shouldn't be sharing.
Okay, great, thanks. Another question, with regards to the workforce continually becoming more mobile, how do we adequately protect data in motion that is better than a VPN?
Let me start on that one. We can protect data at an endpoint. Where this question gets sticky is whether or not it's your endpoint or the individual's endpoint. But nonetheless, if they're an employee and they're doing business-related functions, then you should have the ability to put something on that endpoint which would allow you to classify and protect information that's being generated for business purposes. Well, again, this is something that we have the capability of doing today. We simply didn't have years ago. Scott, any other thoughts on that?
Yeah, I think that it's an interesting question because, a VPN has a very specific function, which is great, but it's not a substitute for data classification, for example, because you still want to know what kind of data is flowing through your ecosystem, and making sure that standards are set so that certain components will say, no, you shall not pass. Okay, this is my experience when I was with a defense contractor, the idea of saying, look, certain documents simply you can't email, or you can only use a VPN. So that all ties back to all the different components of your system. So one won't necessarily substitute for another, it's going to complement it.
Excellent. So there are no further questions. So at this point, I'd like to wrap up today's webinar, and thank you, John, for joining us, and Scott Giordano. I'd like to remind the participants that we'll be emailing a link to the webinar recording, as well as sending a copy of the PowerPoint slides. If you have any further questions, please feel free to reach out to our presenters, Scott Giordano and John Ford at siennasecure.com. That's Scott Giordano at spirin.com. We are going to continue with the series of webinars at twice a month, so please visit our website, and we hope to see you at our next webinar. Thank you again, John. Thank you again, Scott.
Thank you.
You're welcome.
Great. That concludes today's webinar. Have a great day, everybody. Bye.